Okay, hi, this is Michael Feigin, patent and trademark attorney with offices primarily in Clifton, New Jersey, as well as we meet for consultations in Manhattan, as well as video conference via Skype or Google Hangouts or whatever form, what have you. Today we're talking about trademark prosecution. This is the process of obtaining a trademark. So we do patents also, copyrights, all sorts of intellectual property. Today particularly we're focused on how do you obtain a trademark from beginning to end. So we're going to walk through the process. We're going to walk through first how you do something of a search, how you file a trademark application, and how you go back and forth with the trademark office when you after you file it and work with them. So over here you'll see a screenshot of my website, and I will take you down to on the trademarks menu. Then we have trademark basics and clearance searches. So I'm going to be, trademark timeline. Let's drop down to trademark timeline. And here is the trademark timeline. This is what we will be working off of today as our roadmap, which goes through the entire trademark process. You can find the direct URL. The slide is in the video, or if you want to see the direct URL with this and other articles on trademarks, it's just patentlawny.com/trademark-timeline is the first one we'll be working off of. And at the beginning, we're at a preliminary stage at 0 months on this timeline where we're going to search the trademark. So what generally happens is a client will come to you and say, I have a name, I want to protect this. Or hopefully that's how they come to you. They come to you plenty of other ways, such as someone is copying my name, I need to protect this. We you should have come to me a couple of years ago, but all right, let's work with what we got. So first, we're going to do a little bit of searching. So in this example, I'm going to go through an example where a client comes to you with a certain mark, and first thing we're going to do is a little bit of searching of the trademark database and see what's out there. So jumping over to the slide where you can see this is the home page of the trademark office. You jump over to the easiest way is quick links, and then you jump over to TESS, which is search the trademark database. So I'm just going to click on that, and this is the sort of screen that pops up. And then here what we're going to do is we're going to see what are the other trademarks that are out there and how similar are they. So we go over to, I'm going to click on the first one, the basic search for now, and this is a place where you can start. So I'm going to give an example of, suppose your client wants to trademark the name Fancy Star. So you can just type it right in there, and you get something like this sort of result. And here you only have one, and you'll notice that it's abandoned. So generally we don't care about abandoned marks, they're not being used anymore, but you might want to check the abandonment date. So down at the bottom it shows September 8th, 2016. So you might want to do a little bit further searching, because here it's possible they're still using it and just didn't maintain their trademark. In order to have a trademark, you have to have exclusive use over it, which means that you can only register it if you have exclusive use, and in order to maintain it, you have to keep exclusive use. You have to police it and make sure others aren't using it. So we might also do a little broader. So I'm going to go back to the search page. I just went back on my browser. And now I'm just going to search for Fancy by itself. And now you'll see you get way too many to work with. You get 1,040 records. So we're going to narrow that down a bit. So we might go and look at just live marks. You'll see on the search page, I'm back there, it says live and dead as well as live. So I'm going to click on live, and now I'm going to do that query, and immediately you'll notice that jumps down to 334. That's a little bit more manageable to have 334 records, but it's still way too many. So now we're going to narrow it down further. So the way we're going to do that is over back on my website, you will see there is the Trademark International Class list. So that is over on the right-hand column where you're on the Trademark Timeline page, and you can see the international classes. Now, The short version of this is the Trademark Office divides the different types of goods and services that you can register into 45 different categories or classes. And this is an international class system that's used in many countries. In Europe, for example, you'll pay the same fee for filing up to 3 different classes. And to me, that makes sense because if you scroll down, if you look at classes 29, 30, and 31, for example, which I'm going to highlight for you on the next screenshot, you'll see that all of them are related to food. You have class 29 is meat and fish, class 30 is coffee, class 31 is forestry products and grains and fresh fruits. So oftentimes you have overlap, and in the United States it means if you're in multiple classes, you have to file for goods in each of those classes, and you pay a fee for each class. And at each stage, at renewals, at statements of use, which of course we'll get into as we go, you're going to pay a fee for each of those. So in our case, I'm going to do Fancy Star, and I'm going to assume the client came to us for jewelry. So jewelry is class 14, which I will highlight over here. And you can see class 14 is precious metals or alloys. This is basically where any jewelry goes in. And now I'm going to jump back over to the search page again. And I'm going to add here further text. And the way this works is the text as I have entered it is you would put in the word and 014, 014 is the class, and you would put then in brackets IC for international class. You can get a complete list of search terms at the Trademark Office on the website for all of the different search terms that you can type in. This is a common search I can do, and if you familiarize yourself with the codes, it's actually a very powerful search. I don't think it's been updated since late 1990s when they first put it on the internet. But so it's a bit of an old interface, and you can see sort of the style behind the whole search. They're putting everything in a table. I think they probably made this before columns and CSS even existed in website design, but nevertheless, it actually works very well. So I'm going to narrow this down to class 14, and class 14 is now for jewelry, and you'll see I get a much more manageable, if I search here, a manageable 29 results for live marks that have fancy in them. Now you might go through and look at a few of them. So I'm going to click on a few. I'm going to click on number 28 for fancy. I'm going to click on number 20 for fancy doodle jewelry. And I'm going to click on number 9 for fancy chance. And number 3, which is also for fancy. Just for the sake of time, I'm just going to choose a few of them. But in reality, you probably have to look through most of them, if not all of them. And now we're going to see here on your next slide, we have fancy, which it is registered for jewelry. Registered 2000, you can see that it's been renewed in 2010, and it's for all types of jewelry. So this one you would flag and say, hey, this is problematic because likelihood of confusion test. Is it too similar to the other person's mark or not? Is it going to cause confusion in commerce? So if my client, again, on our sample mark here, we're going to do Fancy Star. Client wants to register Fancy Star. Well, Fancy is already there for jewelry. But now as we keep looking, you'll see that there's the next one, Fancy Doodle Jewelry is real and imitation jewelry. You're like, well, Fancy is on more than one mark for jewelry. And yet another one, Fancy Chance. You can see there that this is for costume jewelry. And then Fancy with some, looks to be some Chinese characters. Kanji, katakana, I don't remember. But anyway, no, katakana is Japanese. I'm sorry. This is kanji, I believe. Anyway, doesn't matter. What matters is the translation into English. And so you'll see here, they actually list the translation. So they write fan xi, like fan z, and they said it has no meaning in a foreign language. If it did have a meaning, you'd have a translation, and the translation could be an issue for the likelihood of confusion analysis as well. And they have jewelry. And you'll see over on the, whoops, okay, that's it for that. And you'll see there that there's in fact a couple marks for fancy that, for jewelry, so it seems to be a crowded field. So I might then counsel the client, well, fancy would be a problem because other people have fancy, but because the trademark office has already allowed so many, one more is probably not a problem. So I would give them a tentatively positive thing saying, yeah, you can probably do it. We might get a rejection, but we should be able to overcome such a rejection based on an argument that it's such a crowded field. What's another fancy? And yours is different. Yours isn't plain old fancy. It's fancy star in our case. And in most cases, I've found clients will say, that's great, I want the trademark. And you might counsel a client, well, your trademark is going to be kind of limited because you're not going to be able to stop someone with another variant of fancy because fancy is so used there. And if they want to come up with a crazy name, like for example, if you want to call a book, and you want to register a trademark for selling of books, and you want to call that trademark Kindle, that is a very protectable name because Kindle means you're burning a book. It's sort of the opposite of what you want to do. No one in their right mind would register a trademark for Kindle, but Amazon did that. They marketed it. They put who knows how many tens of millions of dollars behind their marketing. And so we know Kindle as this thing that is for reading books. And okay, you can also argue the other meaning that because you can burn your book, now book burnings aren't a problem. Now you can just read the electronic version. It's all good. So that's a name that's protectable because no one is going to be trading off of anything similar. Now, if you tried to register Kindle Star for books, forget it. It's too close. They have locked up the name Kindle, and they're the only ones out there. You will hear from their lawyers. Now, if anyone who has sold products at Amazon knows what it's like to try and get a hold of a lawyer, it's impossible. Typically, they'll take down your product. This is a whole side note, but they will take down your product, not tell you why. They'll say, here, you're the hen who's just been attacked by this fox telling you that you're infringing upon their product. Go deal with the fox over there and let us know when the fox tells us you can put the product back up. And you try and contact Amazon and you try and deal with it, and they're very difficult. They just take your product down seemingly nonsensically half the time. But that is for another video. Happy to do one of those too. I deal with that a lot. But in any case, if you want to reach a lawyer for Amazon, this is how you can find a lawyer for Amazon, is go file some variation of one of their trademarks, then you'll hear from their lawyers. Alright, in any case, here we are back at fancy. So, and then we might also try another variant. We might try, just for the fun of it, star. And I'm going to limit this to class 14 again, but you will see here that there are 282 references, and you might look through them all. You might try variant spellings. So we might try star, and then we might try things that sound similar. So maybe, I don't know, we'll try the first name Nancy instead of Fancy. So you'll see here, this is what that search looks like, and it comes up nothing. And you'll try different variants of that. Now beyond that, I'm going to go back to the timeline now. Beyond that, there are full clearance searches. I'll just go through that briefly. What a full clearance search is these are reports that you need you go to a company and subscribe to one of their databases, or just pay them to do the search. And this is searching more than just the Trademark Office database, which is something anyone can do. You then search common law databases, which include corporate registrations in all 50 states. They search periodicals, they search websites, they search domain names. And this is what really should be done. These reports cost more money, because this sort of search that I just did could be done, depending on the mark, somewhere between 10 minutes and a half hour. It might be typical for this type of searching at the Trademark Office database, whereas the full clearance searches, you are searching through often hundreds of pages of company registrations and domain names and the text on it. But it gives you much more information. But you might also just go out to Google, which I'm going to do, and you'll see here what happens when I search Fancy Star in Google, just to give you an idea. The Trademark Office generally will not search anything other than the trademark database. which can be problematic because you can get the trademark through, but there might be someone else out there using the name. And so you'll see in this case, when I search for Fancy Star, which is something I made up this morning in preparation for this, you'll see when I do a Google search here, look at this, I didn't even limit this to jewelry. You can see that Fancy Star, result number 2 over here, is for jewelry and it's earrings, and number 3 is for diamonds. And then over here is, funnily enough, I don't think funnily is a word. You can probably register it because I made that word up and I haven't registered it. Go ahead, feel free to use it. I'm not going to. There is an Amazon listing as well for Fancy Star. So I'll just look at those real quickly, and you'll see over here you have Fancy Star earrings, diamond available for custom earrings from this website, blackbirdinthesnow.com, which apparently just got free advertising from me. So they have not registered their trademark. So if they do hear about this, maybe they should come to me and I can register this trademark for them. So that's one reference. And here's another one. You have Fancy Star Diamonds, Marquise. I'm sure people in the industry know how to pronounce that word. Marquise, I don't know, and pear. Pear, I know that word. It's a pear-shaped diamond that I got. Okay, so they are selling diamonds under the Fancy Star name. And over here, you have, on this website, I get, I get Fancy Star Women's Double-Breasted Slim Autumn Long Trench Coat Chinese XL Yellow. I don't know what it is with Chinese references today. There's clearly a Chinese woman in there. I don't know. But in any case, this one wouldn't really be a problem because it's the name Fancy Star, but it's for clothing, not jewelry. There's probably not confusing between the two. Sometimes you have overlap, you have companies that sell in both. But I might click on the Fancy Star name and see what else they're selling just to do a little bit more, and I see, nope, they're only selling coats. They're actually quite nice coats. I mean, they have really lousy ratings, so I guess my wife isn't getting one, but if they had good ratings, if they had 5 stars, my wife might find herself with a gift of a new coat. Anyway, they don't. So now we're going to just assume for sake of argument that Fancy Star is okay to file. Given those references that I just found, even though they're not at the trademark office, since I did find references out there where people are selling Fancy Star under jewelry, probably what would happen is the trademark office wouldn't notice them. They might search Google. I've never really seen them do much more than doing a quick Google search. So in such a case, you could probably get the trademark through, but I would recommend to the client not doing it. The reason I recommend not doing it is you got a trademark, but it's probably not of that much value because there are prior users out there before you who then are using the mark. And since they are using that mark before you, really they have priority to the name, not you. So your filing date matters, but it could be invalidated unless you use it a certain number of years. But even if you use it a certain number of years, you're not going to be able to stop. Realistically, in a normal case, you wouldn't be able to stop a prior user, and then other users come and use that name, and you send the cease and desist letter, they send back, what do you mean, your trademark's invalid? Happens all the time. It's very easy to shoot off a letter. It's much harder to get someone to change their behavior. It's even harder to get someone to pay you money. So best is to have all your ducks in order from the beginning. I would counsel, the way a typical client consultation might go is I would say, and counsel, you really should file another mark. Let's keep searching. And they'll give me 4 more marks that'll have the similar problems because these are the type of names that they like. And eventually you're like, sure, I give in. I do this mark for you. Or they're like, no, just do it. And it is what it is. You put it in writing. You tell them, this is the search results. This is what I found. I don't recommend it. Okay, you want to go forward anyway? Okay, what am I going to do? I'm not going to twist your arm when you're trying to throw a check at me. Fine, I'll take your money, but I'm fully informing you might not want to do this. So, point being, you could probably get that mark through, even given the other close marks, but it's not of great value. Okay, now we're going to go back to the USPTO website, and in the next segment, so this was the first segment of about 15 minutes. Our next segment, I'm going to run through actually filling out the trademark application. So over here again, you have the U.S. Trademark website. Easiest thing is go up to the quick links. They change their design every once in a while. By the time you watch this, they might have changed the design again. It might make more sense, it might make less sense. Right now, in my opinion, it makes less sense because instead of just telling you trademark filing, you have to click on TEAS, teas, like tea with honey. You have to click on that, and you're supposed to know that that means trademark filing because it means trademark electronic. I couldn't tell you what it stands for. I'm sure it means something, and someone who designed it, they're very happy with all their initials.
The first code is 942. The first code is 942.
So on the links, they have PAFT, APFT, FWeb, Forms, Private Pair, Public Pair, and so forth, PTAB. All right, we're only concerned with the trademark side of things for today, so we're worried about TES, TEAS, TISTER, TTAB, ESTA, and TTAB View. We're going to deal with the first two, maybe three today. So we've dealt with TES before, Search Trademark Database. Now we're on TEAS, which in English we would say trademark filing. And we're going to click on that. And here you go and get this screen where it says apply online, and there's different fees. Now, the other thing which the Trademark Office loves to do, in the Patent Office, is they have different fees for the same thing. And you need to know which one to choose. I'm going to run through the cheapest one for the obvious reason that it's the cheapest one. This is the one where you choose the goods and services that you list on the trademark from the manual. The reason why it's cheaper is because before, in the quote-unquote old days, when I started working 10 years ago, that we would enter it freeform. I actually started with an attorney. We filed them all on paper. Today, they charge you much, much more. I don't even know the fee if you file on paper. And it doesn't make sense to do, even when they didn't charge you more. It's just much quicker, more efficient just to use their web forms. It makes it easier. You know you're doing the forms right because it'll catch your errors and won't let you do a lot of things if they're not correct. So in this case, we're going to choose the least expensive one where you actually choose the goods and services from a list rather than entering them freeform. If you enter them freeform, what used to happen is you would enter it as earring. And they would say, no, you can't enter it as earrings. You have to say earrings for the ear. I'm giving a crazy example, but some of them were kind of like that. So this way you choose it from their goods and services list. You can't make that mistake. So it makes the prosecution much quicker, less expensive, and just goes more smoothly. So I'm going to click on TEAS Plus form, which you'll see is $225 per class. And the way this works is then we go on to the next page. Is an attorney filing the application? I assume if you're watching a CLE course, it's because you're an attorney and you are getting this for credits. You don't just for fun watch these type of things, but maybe you're a paralegal, I don't know. But in any case, if you are, you're filling this out for an attorney. You can also, you see here, choose file, option number 2, and you can actually upload saved data. This comes in very handy if, for example, you're filing 10 of them for the same client, or even better, you're filing one of them for a client and you're going to send it to them, and later they say, no, we have to make an edit, or there was some mistake, something was spelled wrong, some date was wrong. You can just upload your saved data. It does not save your trademark on the Trademark Office website. The only way to go back, it does, but the only way to go back and edit your trademark is then to save the data file, and this is where you would upload it. So that is the end of that discussion, but you'll see at the end there is a save data form where you would go and save it if you needed to reuse it. We're going to go ahead and hit the continue button, and you come up with a screen like this where you have Trademark Service Mark Principal Register. Quick note on Principal Register. Principal Register is most of trademarks. That is for the ones that you get statutory damages for infringement. There is something called a supplemental register, which is for marks which are merely descriptive. If you file a name like, I'm doing one now for startabusiness.com, the trademark office had said that is descriptive, which makes sense. It is a website to help you start a business. So they said, we're only allowing that on the supplemental register because it's descriptive. It doesn't immediately tell you what it is. If it immediately tells you what it was, it's generic, not registerable at all. If it describes what it is, then that's descriptive, and until it has quote-unquote secondary meaning, it has a new definition that people recognize startabusiness.com as being this specific website, as opposed to the meaning behind, oh, it's something about starting a business, then it is on the supplemental register. Only after it's then acquired another meaning through either long-time use, usually over 5 years. For start a business, it means even more than that, but typically at least 5 years, or spending lots and lots of money in advertising on it, then it will, then you can get it on the primary register. So applicant information, we're just going to fill this out. You would put owner of mark. I'll put my name for the fun of it. And there you'd see I'd put in my name. I would put in individual. You just fill this out. You put in corporation, LLC, or what have you. So for the fun of it, let's say I'm an LLC. This is obviously not correct, because if I was, I would put my name with an LLC. I'll put state of incorporation. Oh, let's go and put, I don't know, Idaho. I don't see too many incorporations in Idaho, but whatever. It just went down to Illinois on me. And I'll put it in address, and I'm just going to autofill my address here. Thanks to the magic of Google Chrome, it autofills it, and you can see this is what happens when I enter all the data. Now, it just gave me a problem. I don't know what. Sorry for the dead air. Oh, it doesn't like my website address, which Google autofilled, and I went too fast. And now it wants to know, actually remove. All right, I don't really care on this, so I'm just going to go through this as quick as possible. If you enter an individual, I just changed the individual to try and get through it. It wants country of citizenship, so I put United States citizenship. And all right, then we get to the next screen. And over here, you see this is where you enter the mark. You can enter here a standard character mark, or you can enter a special form, stylized or designed. So I'm going to go and do that. And there's two separate marks. If you file a logo is typically you're uploading a JPEG. There's also a sound mark. You could upload a WAV or an MP3 file. You could actually register a sound. Sound marks are actually, they're not that common, but you do actually hear them a little bit more than you realize. There's a fun little page here. The Trademark Office has trademark sound mark examples, which is over here. And a few of them are kind of common. Like here's Lucasfilms. Might recognize that from the beginning of Star Wars. That's actually, I believe, their THX sound. 20th Century Fox has their own. So those are actually examples of sounds which are protected. There's some other fun ones. This one I always get a kick out of. They list on their website. Mail. Play that again.
You've got mail.
That was a trademark sound. In order for them to use that in that movie with Tom Hanks, was Tom Hanks? I don't know, one of those movies, they had to actually license use of the trademark from America Online and pay for it. And there's a ton more of those on their website, which you can play with. Let's see, and then we'll just do one more for the fun of it. That is a trademark sound. It is not, by the way, trademark infringement for me to play this on that video. Reason being, in order to infringe upon a trademark, you have to be claiming to be that source behind the trademark. This is just what's called referential use. Referential use is permitted. People refer to trademarks all the time. Otherwise, you'd say, hey, did you buy that product on Amazon? And you would say, trademark infringement. You can never say that word. It doesn't work that way. No, that's the whole point. You're creating a new word or a new meaning of a word. Amazon obviously had a meaning before. It's the name of a rainforest. I think the rainforest is still there. We haven't got rid of it yet. At least most of it's still there, I think. Anyway, but they've created another meaning for it and said, hey, now this is a new meaning when I refer to it that way. And now you say, hey, did you buy it on the Amazon? And you're like, what are you talking about? Would an alligator chase you down the river? No, we mean you bought that from the company. So now we're going to do the special form, and I actually made one just before. I thought I did. And I'm just going to upload it to show you how you do here it is. So I've just selected the file, and the one I made, apparently I didn't remember my own name because it was Funstar. So you just choose it, you upload it, and then over here, this is what it looks like when I uploaded this quick thing which I just doodled on the computer to register a logo mark. It looks a little like Homestar, for those of you familiar with that. I think that website kind of died. They did one video recently. Anyway, fun website. So you just upload it there, and then you type in the literal mark. So I would type in Funstar over here. For the name of the mark, you put in the colors, yellow, black, or if you're not claiming colors, you check that little box over here, and you would describe the mark. The descriptions really only matter for people searching for marks and the trademark office who cares about them being correct. In terms of trademark infringement, I don't think it really matters what you call the colors or how you describe it, but I'm going to put something in here like a malformed yellow star with a thick black outline above the word Funstar in yellow. And you get something like this, in which case the trademark examiner generally will call you back and say, I don't like that description, I want to amend that, in which case I typically say, you don't need to read me the whole long description, it doesn't matter to me, whatever you want as a description is fine, because it really is for the trademark office purposes more than it is for your client's purposes. Then down here in the bottom, you have click here to display a full list of additional statements. These are things which apply in some cases. You might have over here in the next slide a disclaimer. Suppose I put here Funstar jewelry. The word jewelry I would need to disclaim. What that means is the word jewelry is generic. A generic word, I can't go and stop anyone else from using it. So I would say there is no claim to use this mark, to use jewelry apart from the mark as shown. Then I fill it in like that. And the reason why I do that is because it's going to save me time later when the examiner is going to do it anyway. And the only claim I have to the word jewelry is when it's used next to Funstar in this case. And sometimes you have the name of a living individual. So down below you have names, portraits, signature individuals. You have to state whether this is the name of a real person or it's a fictional name. I once registered Ron Marone for perfume. It was fictional. I had a case where I registered Joseph Edegui, and it was the name of a fashion designer who died a couple of years ago. And they said, no, it's too close to this living individual and so forth. And then I found out, nope, my client, one of the partners was named Joseph Edegui. It was after his name. We put a whole declaration, the whole thing, and we got the mark approved. Translation, as we spoke about earlier, if it has a meaning in another language, you have to put in the translation, transliteration if it's not English characters. Sometimes that will happen in Chinese characters and Hebrew characters, where you put it in a non-Latin character set. You put in the transliteration to say how it will be pronounced. You can register a mark in any language in the way it's written, or the way it's pronounced, whatever it is, but you have to provide the translation or the transliteration in order that someone who speaks English can understand what it says. And again, you could have confusion based on translation. If you file a mark for, let's say, the word for river in Hebrew is Nahal, and Nahal sounds too much like Nicole, someone has Nicole for a trademark, and they'll say, oh, that sounds the same. Or they'll say, Nahal, the translation is river, someone else has river for the same goods. That's confusing. Even though one's Nahal, one's river, it's the same difference. So it can go, likelihood of confusion can go based on sound, it can go based on appearance, it could go based on pronunciation, how people will mispronounce the name. Any of those things are possibilities for confusing people in commerce. All right, we're going to go on to the next page, and on the next page what you see here is this is where you add the goods and services. So you just click on the Adds Goods and Services link over here, and you're going to add them. So here, jewelry, you can actually just type in jewelry, and you'll see what comes up over here is a whole bunch of things, and you can just plain old check the box for jewelry, put insert check goods, and that's it. You'll see here it is on the list. You see jewelry there, but you could also, suppose I wanted to be more specific, suppose I want to put in pet jewelry, click that, and I could put that in. And I can also do the search a little bit more detailed. I could type in jewelry necklace, and this is the sort of thing that I get. And I can put in necklaces over here, jewelry, and I check that, insert checked entries, they're all there. Occasionally, you might do something. You're inserting something like a website, and you get something like this. Providing a website that gives computer users the ability to blank, and you just fill it in. One thing of note is when you list goods and services, you cannot add more later. You can only delete. You cannot expand the service. You can only narrow it. And what is the definition of narrowing or not is a little bit of a debate. When you add more words to it, is that narrowing it or expanding it? In general, it's you versus someone who works for the government. The government usually wins, so you don't want to leave that to chance. You want to put in more is better, but you need to keep in mind that only during this phase. If the client doesn't actually sell something on your list and it is still listed there, there are cases that say that's fraud, cancel the whole trademark, even if one thing there is on the list that isn't, which is sometimes an argument. If someone gives me a trademark infringement, they send a cease and desist letter, and I'm representing a client, and it has 300 different goods listed on their trademark registration because they just listed everything in every category, then you go and respond and say, your trademark's probably fraud anyway. I mean, not saying these words, because you're not selling everything on that list. So show me that you're selling everything first before we bother to take this seriously. And I've never once gotten a response back, sure, here's all the things we sell. You're right, it's still trademark infringement. So you might want to be a little judicious, and you might want to be broad, because suppose I listed necklaces here. Client 3 years from now realizes, hey, they're not selling necklaces, but they're selling earrings. And I've listed only necklaces. Well, now they need a new trademark because they're not selling the goods listed. So it's better to list it more broadly, list jewelry. So now if they're selling any jewelry, if they change from necklaces to earrings, it's not a problem. That then gives them more leeway and more flexibility in their trademark. And you could list both. You could list jewelry by itself, you could list necklaces, you could list earrings, but you need to make sure that that list stays accurate. So, and another way when you're doing the search, you could also type in, suppose now I typed in website, supposing I know my categories of goods. Remember, the categories of goods are listed on my website again under the trademark menu. but I only want goods in class 39. So now I just type into my search something like this, website 039, and here it is. Here is any time the word website is used in the acceptable goods manual that is in class 39, and I can choose from that. So now I'm going to go back, and we're back on this screen where this is what I added. Jewelry, necklaces, pet jewelry, we'll just go with that for now. There are generally two ways in which you're going to file, as currently in use or intent to use. So there's also what you see down here, section 44. Those are based on foreign registrations. We won't be going through that today, but in one sentence, that's if there's a foreign registration, you can claim that filing date and bring it into the United States by submitting an electronic version of the issued certificate or the application, depending on whether you're doing a 44D or 44E. Here, we're worried about section 1A and section 1B. 1A is currently in use in commerce, meaning they already started selling before you're filing the trademark, and 1B is intent to use. This is just empirical, this is not scientific at all, but I found when you file trademarks as currently in use, examiners seem to give you a little bit more leeway in allowing things, because I think it's just psychological. They see the person's already selling this, it's going to do a lot of harm if I tell them they can't get the trademark, whereas if you say intent to use, that's not so harmful, big deal to file another trademark. So in our case, let us choose section 1A, and let's say currently in use. And now what you have to do is you now need to show how it's being used. So then we're going to just choose a file, and this is going to have a picture of how it's being used. And I'm just going to, over here, I'm just going to upload a picture having nothing to do with it. This is a picture that I took in the park the other day, just the first one I opened on my computer to upload, but it would have to show, in the case of a trademark, it has to show the mark exactly as filed, matching colors, matching logo, matching everything, and that has to match the trademark logo or name in which you filed, and that would be a specimen of use, and that specimen has to be on the product as well. So here, and you need one per class. So here I've done them all in one class, all jewelry. So as long as it shows a jewelry item, so in this case it would show a necklace, and on the necklace would be like a hang tag that had my Fun Star logo, that would be fine. If it is a service mark, which is different than a trademark, we call them all trademarks. It's really two different things. And in other countries, they will actually put a space between the words. It'll be trade space mark and service space mark. We don't do that. Trademark has been crunched into a single word in the United States, but they're really two different things. One is a mark which tells you about the trade of goods. You're trading products. And the other, I mean, no one uses wording like that, but the word trademark has survived. And service mark is for a service. So if it is a service, if it's not jewelry, but say retail or online stores that you sell jewelry of others, or it even could be your own jewelry, then that is a service mark. And instead of submitting a picture of the goods, because there are no goods, you can then submit advertising. Advertising is something you can't do with a trademark. That's not good enough. You need the actual product. If your advertisement shows the actual product, that's the exception. That's okay. But for a service mark, you can show advertising. You can show a picture of a storefront. You can show a screenshot of a online store. Those type of things all work. So you would attach the specimen. You describe it. It's a specimen. The description of specimen isn't that important, but you might want to say what it is. It's a screenshot. It's a picture of a necklace. Sometimes it's not so apparent from it. And you would put the first date of use anywhere and first date of use in commerce. So I'm put over here, we'll just put 01/01/2017 in both of them, and you end up with this. You hit assign filing basis. And you end up with this, and it says assign filing basis 1A, 1A, 1A on all of them. Now, just to show you, suppose I made a mistake, I can select them all, and I can remove them, and I could add by clicking here, remove check goods and services, or I can click on this 1A thing over here, and I can hit remove this 1A, and I could instead put section 1B, intent to use, and they make you do this little checkbox that says, I swear in my grandmother's grave that I really do intend to use this mark as I have filed it. Click on assign filing basis. I have just changed this from 1A, currently in use, to 1B, intent to use. Continue. You enter. Then on the next thing, attorney name, address, and so forth. We'll just autofill this. You put in your docket number, so on and so forth, and you end up with something like this. And there you go. And then they ask you to go through it again, and you confirm it. Most important thing is your email address. They will contact you by email. You check the box authorizing them to contact you by email. Additional fee if you do not go by email later, and they have to do things by mail. And then you get to the signature page. Signature page, there are 3 ways in which you can get it signed. You can sign directly on the form. You can sign on behalf of your client. I think that's a not good idea for a couple reasons. 1, you sign on this application and there's a mistake. Client now comes to you and says, there's a mistake on the application. It's your fault. Fix it. It might not be fixable. Maybe it's not even your fault. Maybe they told you they're selling apples. They're not. They're selling penguins. You thought I was going to say oranges, didn't you? I wasn't. They're selling penguins, and you're like, no, I read your handwriting. That looks like apple. It's penguin, and so forth. It's a problem. You signed it. Now they're mad at you. You have them sign it. They had to read this whole thing. They had to agree to it. You're like, there's an error on it, which it happens. You know, everyone's human. And you can point to it and say, you signed the application. I told you to read it. Did you read what you signed? You signed it this way. So, you know, I'm sorry. I'm happy to fix it, but now it costs something. Now there's a new fee. There's a new whatever. Maybe there's a lawyer fee to do it. We have to redo it. So those can be major problems. The other thing is, suppose you sign on there and you sign this document saying it was used as of January 1st, 2018. Now, what happens? Then it's in court and there's discovery from the other side and so forth, and it turns out there was no use that date. They can't prove it. Now they come back to you, you find yourself subpoenaed, maybe without being paid, and they said, okay, you signed this document. What evidence did you have? It was sold January 1st, 2018. My client told me. Well, maybe you have records. Maybe you have records and you have a clear email, you have a clear who knows what, your client told you that and it looked all good. Do you really want to have to keep those records? Do you really want to have to be responsible for that? You let your client sign it. Let them depose your client, not you, for signing saying it was that date. Who needs that? It's a liability headache. It's an everything else headache. Now, there's occasions, if it's a certain client, it says, I don't want my name on it. I'm filing the name of the LLC. I don't want my name. I will tell them, you must clearly indicate that you understand that it had to have been sold, and I do everything electronically in email, that it was sold to this date, there are these such and such liability issues, and you assert that this is correct, and so on and so forth, and then the judge will say, yeah, fine, not a problem. So hopefully it never becomes a problem, but rather avoid that. Generally, we'll choose the second thing here, which is email. You see, after I click on it, you get this, email text form, second party for signature. And then you would have them type in, you can type in their name for them. So I'll just type in this fictional name and his position. We'll just call him the owner. Phone number is not legally required as far as I know. They asked for the phone number. I guess it's some kind of identification. I just leave it blank. I tell clients to leave it blank. You really want your phone number in your trademark application so spammers can call you. And then you hit validate. The other way is handwritten pen and ink signature. I have done those. Never. Not one have ever done those. I couldn't tell you how to do it. I guess it gets printed, they sign it, you scan it, you upload it. I don't know. I just have them sign it electronically. So then it gives me this error, phone number is missing, I don't care, I just hit continue, and you get to this screen where it's done and you can review it. You can click on input, you get a screen like this, and it shows you the exact input that you put in. You can click on mark, it shows you the exact mark that you put in. You can click on XML file if you really are in for pain, and you get the actual data that's stored there. And you can, before you click on text form for e-signature, you probably want to download portable data. And what you do is you would just save that, and it saves in a .obg file. And that OBG file is then, it can be uploaded, like we said in the beginning, you can upload it again to refile, or to not refile, but to populate all the forms again and make edits. So we'll click text form for e-signature. You get something like this. Read it, review it, make sure it's all correct. I note that I very quickly auto-generated the data, so I note that is not my fax number. Please do not send faxes over there because it will just ring to my regular number. Anyway, so that's my office number, 973-685-2580, and so forth, and you get this type of thing. And the client has to check all these boxes, again, swearing on their grandmother's grave that everything is accurate. And then the way, and then there's a signature here. And then we're going back up to the top again. You don't actually sign here. We're emailing this to the client. You click send the text form to authorized signatory, and you get this kind of thing, e-signature request form. And you put in your name here and your email address. So there's my name and my email address, and click send email. Now what this will do is it will generate an email, which I will pull up very quickly. And you will get the email to you. And this is what the, hold on, let's put this on its own page, because you don't need to see all my contacts. I'm sure there's a way to do it. Oh, here, in new window. All right, and let's full screen this thing. And you get an email that looks like this. It says Michael J. Feigin-esque request. Well, I figure if I'm not pronouncing the trademark office's abbreviations, I won't pronounce mine either. Michael J. Feigin-esque requests you e-sign the trademark service mark application. And you'll notice that fun quirk of the English language where trademark is one word, but service mark is two words. All comes back around in a circle, you know. The principal register. And here it is, and it has a timestamp. It has your IP address on it, which is wonderful. I guess my IP address is now public. And, well, it's on any of my emails I send anyway, I suppose. Any case, here is all of the what you get in the email. And typically what I would do is I just copy this one line here, and I write the client, Dear client, please find below a link to view and sign your trademark application. Please check it carefully for accuracy and ensure that all data is correct. We cannot correct it again later unless you, whatever, without headaches and heartache. So make sure it's right. If and only if everything is correct, then you will sign your name. The way you will sign your name is you will type a slash, their name, however they want to sign it. They could sign it the number 3 and a slash again. They could type slash, the full name, slash again. Important thing is the beginning and end is a /, and that is considered an electronic signature. So when you click on this mark, then what you get, you click on this link rather, when the client clicks on it, they get this. They see the whole application and they can read it. They can click on that underlined mark. They can click on International Class 14 and it shows them the data. And at the very bottom, they get these check boxes. So they check those check boxes. So I'm just going to check those all quickly. It's probably worth reading through at least one time, the first time you do this. And all this other stuff. And then they sign it. So I'm going to sign this client's name. Plony Almoni. They enter the date. And you end up with this. So again, slash name slash. You will get, occasionally you get clients who cannot figure this out for the life of them. You could send it to them on paper, I suppose. I had one guy, I just said, come into my office, I'll do it with you. I opened up with this, I had it here, had him sign it. whatever you do, don't sign for your client when it's listed their name. Sign your name, but not their name, because now you have a ethics issue. Then they click on the sign button, and they get this page which says, hey, your application has been signed. Great. Now that comes back to you in your email, and you go and get this sort of email, which looks a little bit similar to the last one, where it says, great, someone signed it. They don't give you the courtesy of telling you what they signed, they just tell you there's a signed trademark application. When you have 8 of them that come back to you in the same day because you did all your trademarks in one day and you don't know which is which, it can be a little confusing, but nevertheless, you can click on submit, open it up, and you have this familiar page. The one difference on this page is when you click on text form for e-signature, you will see that at the bottom there is the signature. So that's how it works. It's all by email. You have the link come to you in the email when you prepare it. You then send it to your client with instructions. The client then signs it. It comes back to you with their signature, and then you have it here, and then then you're ready for filing. Review it one more time. You put in your email address for acknowledgement. They put it in once. You put it in a second time to make sure, like this. Click the box down here, which I probably read about 10 years ago. I don't remember what it says. I'm sure it's not important. I mean, it is important. Forgot liability and stuff I say. And you hit submit, and then it will go to the credit card payment form, and you pay the credit card. Okay, then if all goes well, you now will have a trademark application which is filed, and you will get emails which will inform you of same. And then what comes back, let's go back to our timeline. If you remember the timeline from the beginning, that's over here. That took us through searching, that took us through filing, and now we are up to examination. In the remaining few minutes, I will go through a little bit of examination, and we will stop there. And in part 2 of this lecture, should there be a part 2 of this lecture, we'll then go through publication, allowance, statements of use, and so forth. But for this first hour, we're just going to touch on examination, and we'll go through more examination hopefully in part 2 as well, should the CLE provider have me back, and you get something like this. This is for a mark which I filed, which was similar, for Brystar illusion. So this one, they went and said likelihood of confusion. Why? So likelihood of confusion based on this mark for diamond illusions, which I have highlighted here for you. And they said it's too close. Your Brystar illusion, they're diamond illusions. You're both selling jewelry. It's too close. They write over here. Marks are compared. This is typical boilerplate language that they use. Their appearance, sound, connotation, commercial impression. The problem is what the trademark office will do is they will search really based on only the name of the mark itself and the goods, not much else. I've rarely seen them list anything else. They could, but usually it's this very formulaic sort of thing, in which case there's typically some sort of formulaic response depending on the nature of it. So in this particular case, on Funstar, you might get the same sort of thing. You go out, you do the search. Suppose we got something like this on Funstar, and then you would go and say, well, here's 5 other marks for it was Fancy Star before, for Fancy Star and Funstar. There's 5 others. Come on, what's a 6th one? It's not confusingly similar. And so in this case, you can actually, all this is public data for trademarks once they're filed, including clients' informations and name, everything that they file in here. So I went and filed a response which looked a little bit like this. And I went and you pull up the things. Usually you can go right from the trademark manual, the TMEP, the TMEP. You find the issues, commercial impression, dilution, just go through the statute. This is what it says. This is why it is and why it isn't. And I said that it is not because there are so many more for this, and the overriding portion of our mark wasn't illusion. It was Brystar anyway, and there's so many others for illusion, and it's so common. It's not a problem. And this argument worked. because if it didn't, it probably wouldn't be the one I chose to show you. So I chose to show you the one that worked, and here it is. So, and there was another thing I wanted to mention. So this is what happens, and then it hopefully gets allowed after that. If not, you can get a final rejection. There's appeals and so forth.
The second code is 539. The second code is 539.
But for our purposes today, this is just a little taste of what happens during examination and the responding. If you have any questions, any feedback, you can obviously write to the CLE company, or you can also write to me personally. I'm always happy to discuss these things and talk about it. I like to teach. I have my videos, in fact, on my own YouTube channel. You can just look me up, Michael Feigin on YouTube. You can find it there. All my prior videos are on my website. Or you can email me, michael@patentlawny.com. My website is patentlawny.com. And you can find my other videos. And that is it for today. Feel free to write me and ask me if I remembered the one other thing I wanted to mention, which I don't remember right now. It was a good one, so maybe I'll remember by the time you write me. But thank you for watching me for an hour, and that is all for today.